Good afternoon and welcome everyone. My name is Lata. I'm a graduate student of the University. Ladies and gentlemen, it's my honor to greet all of you who have kindly joined us in the University. It's my huge pleasure to welcome you to the 6th International Scientific Conference, Federalism, Contemporary in Public Law. Fortunately, having sparked interest in most researchers, this event has become a good tradition. Well, what brings all of us together 6 year consecutive year and today as well with a lifelong interest is comparative federalism. Comparative federalism implies enormous scope for research, including retrospective and prospective analysis, studying common and distinguishes. Comparison incomparable at first glance. Nevertheless, we're going to shed light on the peculiarities of the contemporary federalism. So our today's agenda is to delve into both theoretical and practical issues on the comparative federalism. We are going to explore experience beside our country, such countries as India, Ethiopia, Bosnia and Herzegovina, countries from Latin America. So I wish you good luck and enthralling discussions. Please do not hesitate to share your even mind-boggling ideas. Dear experts, it's my honor to greet you today. If you would like to give us an introduction, even a brief introduction, please don't hesitate and take the floor. Well, now I would like to start the session. This session is an expert one, and I will ask her to take the floor. Nicholas Aroni, PhD in Law, Professor of Constitutional Law School, the University of Queensland, with the topic Comparing Constituent Power in Federal Systems. Please, Dr. Nicholas Aroni, take the floor.
Thank you very much for the invitation to speak to you all today. My topic is, and can you see the shared PowerPoint that I've tried to share there? As you'll see, my topic is constituent power in federal constitutions, and it is part of a very large project funded by the Australian Research Council, which is undertaking a cross-country comparison of how constituent power is developed or how it exists in different federal systems. And what I want to do, because I only have, is it correct that I only have 10 minutes to speak?
Yes, sure.
Is there time for questions after, or is that included in the 10 minutes?
Yes, of course. We're going to have a brief discussion of the topic.
Okay, because what I particularly wanted to do was to actually ask some questions and get some engagement with you all, particularly because many in the audience understand the Russian system very well. I'd like to understand more about it. So let me explain the problem or the question, and I'll explain it in these terms. It's something with which I'm sure you're very familiar, that you would understand the concept of constituent power and its relationship to the constituted power of a constitution. You probably also understand that it is while it is a widely used concept, it is also a highly contested concept. In its classical formulations, particularly developing out of French state theory, it tends to presuppose that the people are unitary in nature. There is one people behind the constitution. But what complicates the matter in a federal system is the existence, at least in some cases, of a plurality of peoples in the plural as distinct from a singular people. And the question for federal systems is, well, how do we understand constituent power in federal systems as between a unitary conception of the people on one hand and a pluralized conception of the peoples in the plural on the other? And how do they fit together? Our large project of comparison has to grapple with the difficulties of working from one end of the spectrum thinking about the theoretical concept of constituent power and how it works theoretically, and empirical comparison of the way in which particular constitutional systems embody constituent power, or how they refer to the constituent power, or how constituent power is exercised in the formation of each system. And many of you would be aware that if we look at, say, for example, the preamble to a constitution, or often the early clauses of a constitution, we see a constitutional expression of a particular view of the constituent power. Many people are familiar with the way in which the United States Constitution begins. It speaks in the name of "we, the people of the United States." Notably, the term people is in the singular, and the term united implies that the states are united, but the states themselves are plural. The Australian Constitution begins with these words. It recites that the people, in the singular, of New South Wales, Victoria, Queensland, and so forth, agreed to unite in a federal commonwealth. So notably, it uses the word people in the singular, but refers to a plurality of constituent states and the people of each of those states. The Ethiopian constitution probably represents the strongest contrast to these, for it speaks in the name of the peoples and the nations and the nationalities of Ethiopia, always and consistently in the plural and never in the singular. I could give many, many more other examples of federal constitutions that will address this question of a singular people or a plurality of peoples in different ways. And one can go beyond just the preamble to the early clauses of the Constitution in order to try to get a grip on how the Constitution itself treats of the constituent power. What I want to turn to now, though, is to actually make some observations about what I understand to be the relevant provisions of the Russian Constitution. And the reason for that is not to tell you anything about a system that you know so much more than myself, but actually just to raise some questions for discussion, because with your consent, I would be very grateful for your own views about how the constituent power in the Russian Federation is organised and understood, if you don't mind. So what I notice about the preamble to the Russian Constitution, and I'm working, of course, from a standard English language translation of the Russian, is that it begins by saying, "We, the multinational people of the Russian Federation." So in English, at least, one sees a singular people, but immediately qualified by its multinational character, many nations. And also, it's spoken of as a federation, not as a state in that sense. Nonetheless, I also notice that the preamble refers to the preservation of state unity. It refers to the principles of the self-determination of peoples in the plural. It speaks of a fatherland in the singular. And please correct me whether these English translations are correct or not, or whether there are nuances in the Russian that the English doesn't capture. But I also noticed that in the English translation, it refers to the sovereign statehood of Russia. So several of those provisions, at least in English, suggest a singularity, as it were, of the state, and perhaps even a singularity of the people, while nonetheless recognising a multinational nature of those people. There's an emphasis on the sovereignty of the Russian people, and the sovereignty and source of power in the Russian Federation being in its multinational people. Article 3, sub-article 1 says that. So I see in the Constitution some very interesting and very apparently straightforward statements, but ones that interestingly are combining this theme of unity with plurality in the way in which the constituent power is identified and explained. I notice also, say, in Article 5, sub-article 3, a reference to state integrity and the unity of the system of state authority combined with the division of subjects of authority and powers between the bodies of state power and the state power of the subjects of the Russian Federation. So once again, I think I see even in that clause, speaking of the federal structure of the Federation, that on one hand, there is the integrity and unity of state authority, but then there is also a division of subjects of authority and power, reflecting again that singularity and plurality theme running through the written text of the Constitution. Finally, and I think there are many other provisions of the Constitution that reflect this, of course, but it seems to me that of similarly critical importance are the provisions of Article 135 and other ones after that dealing with constitutional amendment and review of the Constitution and of the role of the different institutions in the Russian Federation in initiating proposals, President, the Duma, and so forth, or the Council of the Federation, and the particular rules for the amendment of the Constitution, noting that the power to make a constitution is, of course, very significant, but the power to amend one is of similar weight. And even if it's not strictly constituent power, it's something very close to constituent power because it's the power to change the constitution. And the one last thing that I find very interesting is that under the heading, at least in English, of concluding and transitional provisions, I read that it says that the day of the nationwide referendum of December 12, 1993 shall be considered to be the day of adopting the Constitution of the Russian Federation, which seems to me to be suggesting that the Constitution says that one should deem the date of the referendum as the date of the adoption of the Constitution. And I would be interested to know whether that means not just the date of its adoption, but the date of it coming into force effectively. It seems that way, but perhaps you might need to correct me about that. But that seems to be a way of linking the sense of the constituent power being expressed through that referendum. I wonder about that. I'd be very interested to be informed about that and whether some of the assumptions I'm making about the Russian system or the points that I'm making, whether they are in fact borne out or not. Now, if you will just bear with me, I'd like to just try and turn off this slide if I can, but I don't seem to be able to do it because what I wanted to do was just make one final observation. In fact, I'll do it without it, is that from what I understand, that referendum that was held adopting the Constitution was as it were, Russia-wide referendum. And it was carried by a majority across the entire Russian people. Again, on the face of it, treating the Russian people as a unity and not as plurality. But I also see records that have very carefully indicated the particular votes in each of the particular subjects of the Federation and the percentages or numbers of the turnout of the vote and the result in the vote. And also I note that if I got my numbers correct, but I may have made a mistake, that 17 of the subjects of the Federation, according to at least one list, had voted no by majority to the proposed constitution, whereas an overwhelming majority of the subjects of the Federation voted yes. I draw attention to that because, and my final point is that in Australia, for example, the Federation came into being not because there was a nationwide referendum of all the people of the nation, but rather there were referenda held in each of the 6 constituent states. And only when each individual state agreed to the Federation did it become part of the Federation and the Constitution was adopted, which reflected quite a pluralised conception of constituent power at the very foundations of the Constitution. Whereas from what I can glean from the information about the formation of the Russian system, the origins were relatively more unitary, focusing on the Russian people as a whole, while nonetheless recognising the many subjects and the many peoples, as it were, that make up that federation. but that's just based on some textual analysis. I would very much value you telling me the ways in which perhaps the reality might align with what the text says, or perhaps the reality was more complex than what the text says, and what insights that might have for the way in which the constituent power was structured in the making of the Russian constitution. And then finally, whether you have any comments on any official decisions about that, whether in any of the judicial decisions that have been made at any time, or any official proclamations, or any other important literature that sheds light on how the Russian self-conception of constituent power has been realised or articulated. That's what I wanted to convey in my short 10 minutes. I hope I haven't gone too much over time, but I very welcome any comments or advice that any of you might have. Thank you.
Well, dear Dr. Nicholas Brownie, many thanks for the introduction, for the opening our session. Dear colleagues, when you have some questions, please, it's high time we asked our first speaker, and please delve into the discussion. Do you have any questions?
I'm sorry. So may I raise an issue? So I'm very glad. I'm sorry that I was not in your company just from the beginning. It was just technical problems. I tried just to do it earlier, 15 minutes earlier, but for different reasons, I'm only now on the air. So but anyway, I heard quite a lot from the previous presentation, and I have a question. Now, especially in the international law, term peoples in plurality is used broadly, and especially when it deals with the name of indigenous peoples. And some persons from indigenous peoples even insisted in using indigenous peoples even when there is only one people, just saying that people is just a plurality for a person, while peoples signifies something different. From that perspective, if it is possible to use also in the context of federalism, I understand that not for all countries it's suitable, because, for example, the Constitution of the United States begins with the words, "We are the people of the United States," and so on and so forth. And this was the reason for the Supreme Court once to adopt a decision that it is impossible to dissolve the Union of the United States because it's just unique people. But anyway, in certain situations, actually, in the modern time, we have the possibility of emphasizing that there are different peoples. For example, in Belgium, they have in the Federation of Belgium, they have not only territorial units, constituent units, but as well communities. And that is why there are 3 units, Wallonia, Flanders, and Brussels, which is bilingual, and 3 communities as well, which is not coincide completely with territorial units, which are Francophone, Flemish, or Netherlandian, if I may say so, at least in, they prefer this language, and German. So from that point of view, if it is just till now, we insist on using the only word people for the federal states, or we may use peoples in certain situations. It's just a question, because it's a very interesting question, and I think that we need to discuss it, because still, if it is a state as a constituent unit, or a state in the international understanding as well, especially so But I put aside this issue. I raise a question about the peoples, and on the other hand, we have some federations as United Arab Emirates, for example, where emirs who united but not peoples, or people, I don't know if we may say so. From that point of view, to what extent we may use peoples in plural just now, as opposite to people as just a plurality for a human being. So thank you very much. I'll be very pleased for an answer, although I understand that's not an easy question. It's something, as Hartman said, just unsolvable question. It's possible to solve these issues in the whole history. Thank you very much.
Thank you for that question, and indeed that very astute set of comments with which I agree in terms of the analysis. I think when we use the term people or peoples, as well as nation or nations, that there's degrees of ambiguity or various definitions or understandings to do with, perhaps on one hand, whether or not there's a relationship to territory, as you pointed out, whether or not there's a relationship to sovereignty, and of course sovereignty itself is a complex concept, and I think also whether or not it is related to other indicia of peoplehood or nationhood, whether that is like language, culture, ethnicity, tradition, history, and so forth. And so I think that one always has to be very careful with these terms and understand those complexities. I also tend to think, and I'd be interested in what you think, but when constitutions use these words, sometimes they are deliberately ambiguous. Sometimes they do have a precise meaning, or at least amongst all of those variants of meaning, one might exclude some and include some, and there seems to be fairly good evidence to support that. But it's always very difficult from a distance to get a firm view, and I think it's very disputable and debatable. And I think, as you pointed out also, in the plurality of peoples, we could be speaking of, the many human beings, as it were, as distinct from the people, or many peoples, not as distinct individual human beings, but as distinct peoples. And I think the problem of federalism tends to be more about that latter question, about peoples and people understood more like nation and nations, or at least analogous to that, rather than the individuals as pluralities within those people or peoples. And I'm very curious about that. In fact, and my last observation would be in terms of the international law dimension that you mentioned. It is very interesting how the Russian constitution appears to refer to international right to self-determination of peoples. And I wondered as I read that, whether it was intended to refer to peoples within the Russian Federation that may not have territorial rights, or in fact do. And I noticed that, for example, in Article 5, sub-Article 3, it speaks of the equality and self-determination of the peoples of the Russian Federation, after immediately talking about the subjects of the Russian Federation. And I didn't know, and I wondered whether that was implying that there was meant to be some sense of, to some extent perhaps, a relationship or even an identity between the subjects and the peoples. But then I noticed another later clause, and I'd have to dig for it to find it, which refers to, I think it's Article 69, speaks of the rights of indigenous small peoples, according to norms of international law, which seems to, with that qualification, indigenous and small, distinguishing it from those other peoples referred to above. And so I'm quite curious to understand from a deep Russian point of view, what is meant by these phrases in a more precise way, noting the complexities that you've just so rightly and helpfully drawn attention to.
Thank you very much. Thank you. It's interesting. Just if, with your permission, a few words. In Russia, it's a very peculiar situation because there are different calculations, but in any case, there are more than 100 peoples or nations who live within the territory of Russian Federation. And so from that point of view, it was a long discussions about the indigenous or indigeneity within the Russian Federation. And it's considered that there are a lot of indigenous peoples in Russian Federation. But why it is necessary just to point out small in number, small means only numerically small nations, who would like, because of their small number, are supposed to have some special protection. So, for example, they're free from conscription or some, even during the wartime, they're not prohibited just to serve as a volunteers, but usually they cannot be invited to the army without their consent and so on, while all other peoples have the same right, and some other privileges that they are supposed just to have because of their numerous, and that's why they're the most vulnerable. And by the way, during the last census, there is a couple of peoples who are numerically so small that even around 10 or even less than 10. For example, Karaks, who live just in Chukotka, only 11 persons who proclaim themselves as Karaks, and some people some scholars say that in reality they are also some Métis people, just because of mixed marriages, but it's up to them. According to the international law, they have the right for self-identification. If they feel themselves as Karaks, nobody can say that they are not. So from that point of view, it's up to them to say. But anyway, it's around 11 persons who considered to be a separate people. This also creates some problems for them for the territorial self-determination, because not only them, but we have as well as such a people who is called Evans. There are Evanks and Evans, different as well. Evanks have their own territorial district, but Evans no, because it's a smaller number, less than 30,000 persons, but they live on a very vast territory occupied by other peoples as well, in Yakutia, in some other regions, and they are nomadic people, so that they are just moving all the time around this territory, but it's impossible to say that this is the territory exclusively for them. While other peoples, even they may be not so numerically big, but they have more or less the core territory, which might be referred exclusively to them, although other peoples as well live there on this territory. So that's why it's ambiguous sometimes. That's why it shows that sometimes it's difficult to connect completely territory with persons of certain ethnic belonging. That's why it's also sometimes difficult also to understand how and at what extent it was done. I know that in some other states there are also some difficulties with all this, as there is a problem of, for example, people who are considered to be Native Americans in the United States who live outside reserves and reservations, how they are considered. There are problems for some of them just to return to their territory, although everybody knows that they are of certain ethnic belonging, but if they might be considered as dwellers of a comparative Europe or not, it's another issue. I know that also it's a problem probably in Bolivia, which is very favorable for the indigenous peoples. But when they proclaimed that it's indigenous peoples, connecting them to peasantry, this is indigenous campesinos, indigenous peasants peoples, it's appeared during the last census that not all, that the quantity of certain peoples just decreased. And it was very strange for the previous president, Evo Morales, who was very surprised with all this. But to my mind, that some city dwellers who are indigenous as well maybe do not like to be peasants. I don't know, but it's also a probable situation. So from that point of view, it's also very interesting, and we need just more emphasize on all this, and probably we need more more research in this field. I do not have an answer to on everything. But thank you very much just for raising many issues, because it's dealing, sometimes it's dealing with federalism, sometimes not, but it's very close to the problematics of comparative federalism. Thank you. I'm very pleased just for being invited. I'm very pleased for the report, and I'm very pleased for your answers, and just some meal for my mind just to think over and just to continue to think in this direction. Thank you. Thank you.
Well, dear colleagues, many thanks for your discussion. You have given much food for thought for us, and unfortunately we are under the pressure of time, and if you don't mind, we will go further. And I would like to invite our second speaker, Alexei Avtonomov, Doctor of Law, Professor, Head of the Department of International Law and Legal Regulation of Foreign Economic Activity, Rovayev Institute of International Law and Economics. The topic is federalism in the context of legal topology, parameters of comparability. So please, you're welcome.
Thank you very much for giving me for giving me the word, and I'm very pleased just to take part in all this. And I'm sorry for being so talkative after the previous report, so that's why I try to save some time just being very short, because it's impossible in any case to raise all or just to explain everything what I'm supposed to say, because I thought about the topology. We just touched upon the territory and people, because in any case there is a obvious connection between the territorial organization of the state and the regulation of space. I mean, just regulation of room within any country. So from that point of view, I think that it is necessary to introduce a little bit just further research in the field of topology. Topology usually utilized by mathematics in the field of, as they say, it's just different from geometry, and sometimes they're called topology is a part of the mathematics. They call it geometria situs, or in Latin as well, analysis situs, which means that they try to understand the deformation of space in general, room, and how it is used in the modern society. So I think that we in law also dealing with the development of space, the development of territory, although it is not paid a lot of attention to the territorial, sometimes we use the word territorial settlement, but we use this word first of all just in the meaning of boundary delimitation or something like this. While I think that we need a little bit more just to look at the role of law in the field of connection between people and territory, between people and the development of territory and development of room in general, because actually we also do not use only territory. We attached to certain territories in the field where we mentioned indigenous peoples there. I'm sorry just going back to this, but they are usually it is said that they are very attached to their territory. That's why their concept of land is different from the just European or Western notion of ownership. But not only indigenous peoples, any people, any person is attached to the territory. It deals not only with sedentary persons, sedentary peoples, but as well with nomadic peoples. They also use the territory, although in some different connection. From that point of view, I think that the federation and federalism also gives us some possibilities for this settlement and development in territory. But we didn't note it, and we didn't pay a lot of attention to this part of the legal work. What I'm thinking about that we need as well in the context of federalism. Usually, we compare. We compare usually the structure of government, which is important, of course, the quantity of constituent units, or in Russian constitution we call it subjects of federation, which is not quite correct. It's first of all entities. I think we may use it subject, but in English subject a bit ambiguous. So that's why I still use the word constituent entities of the federation. But it's not quite clear to what extent people are involved in all these constituent entities, and sometimes it's difficult to understand. We say that people are connected to certain territories, and even in the previous times, for example, Swiss Confederation, we call it confederation, but in German, it's Eidgenossenschaft, which is a little bit different. This is just partnership based on and off, which is not completely what confederation means. And so Italian and French speakers didn't find any better translation. That's why they translated as a confederation. But it's based as well why it's based on an oath. We know that historically Swiss Confederation appeared as a union, and union based on an oath of 3 cantons. In the beginning they were German speaking, only later some other speaking people also joined. But there was a space, there was a possibility for other non-German speaking peoples as well joining the Swiss Confederation. So from that point of view, it's also connected to an extent to different peoples. Once we discuss if linguistic communities means different ethnic belongings as well, because they're connected as well to the territory, but sometimes linguistics also, it's only one property, only one virtue, I may say so, of persons to show their differences from other people, but it's not quite clear if it is ethnically different or linguistically different. It's also a question which I first of all raise rather than just answer. So from that point of view, there is federation gives possibility for different peoples and different nations live in one state for the sake of the situation that federation is a unity in plurality, or plurality in unity. It's also might be saying this way, and that is why this form of territorial organization is interesting for us. It's interesting for the possibility of unite peoples of different belongings. But till the beginning of the 20th century, when it was said as something new word, and it was not only the Soviet Union who proclaimed this resolution of the national or ethnic question for any state. Even previously, empires as well, based upon differences in culture, in linguistics, and so on and so forth. But empire always considers that there is a leader to whom peoples join. So that is why we had empires, different since Roman Empire also was a state, territorial state in the late period of many different peoples, but they have an emperor who was the unique for everybody. Only 20th century we say that now peoples can unite and can join each other, having the same rights. So the equality in human rights, which is important since the late 18th century, can be embodied in federations as the possibility to live in one state, preserving their own identity on the one hand, and preserving their equality in rights with all other peoples, that there is no any people leader or people who is just following the others. There was a solution. Such a solution was also chosen by some other states as well. It was India who tried just to also unite different ethnicities and tribes and linguistic groups in one, or religious groups as well. Plurality in religion sometimes it's also very important for many people. So in India, for example, in some to an extent, Urdu is comprehensive for Hindu people, and Hindu people can understand Urdu. It's some kind of mixture in reality, although in scripture is different, but pronunciation is very close. At least I noticed as Pakistani spoke to Indians without any problems. But anyway, the religion is the main divisive point in this. So Muslims versus Hindu people. But the possibility to live in one state still preserves. So this is a new response, in my opinion. Federations, real federations appeared just at the end of the 18th century, because it's some kind of a response to challenges of modern world, to challenges of plurality of identity, which is important in my opinion. So that is why this is a possibility. So Belgium, as I also mentioned, also have chosen this way of resolving the problem as an alternative for complete separation of different communities. You see, then Ethiopia as well, which is also a multi-ethnic and multi-religious state. So from that point of view, I think that topology, I understand that I'm very I don't mean to abuse my right to speak, and that is why I'm just very close and more raising issues than giving answers. But in my opinion, that kind of discussions, which are quite short, is just to raise issues, and probably in the further researches, me and my colleagues may answer those questions raised. So in my opinion, that the topology, which should be considered as a legal topology, as a legal regulation of connection between peoples and territories, should be one of the directions for the further research in the field of federalism. So thank you very much. I don't mean just to go further, but and farther, but I'm ready to answer your questions. Although this topic is unlimited in reality. So thank you much.
Dear Professor, many thanks for your report. Dear participants, do you have any questions? Please do not hesitate. Well, sure.
Thank you for your speech. It was very interesting. And my name is Sergey Bashkatov. I'm a student of Russian State University for the Humanities. And I'm going to ask you such a question. Do you think could an Unitarian state provide, as you noticed before, a plurality in unity as a federal state in the circumstances of 21st century? Because maybe the Unitarian form has different features, could provide the same plurality. It's like cases of Italy and Germany in Europe, because one of them is federation now and the other is not. Thank you for your reply.
So thank you for this question, because in the beginning I planned to touch upon these two examples because they are very vivid. But finally, when I realized that it's the time is short, I decided not to raise this issue, which is very important as well and very interesting, because in many cases this is the historical roots which lead us to a federation, as Germany and Italy, for example. But what about Germany? I do not know. Probably to an extent, this is the period of Nazism, which is just pushed the new Germany to federation because it was just under Nazi regime when it was unified completely, because previously both the German Empire, I mean just the empire under the constitution of 1871, so Reich, and the next the Republic, the first Republic in Germany, they were just inclined to the federation, but while Nazi regime just tried to eliminate all differences and proclaimed the uniqueness of the German nation. So that is why probably that Austria preferred just to stay aside, because you know that one of the pretexts for Anschluss, for joining Austria, was the decision of the Austrian Parliament on the 12th of November of 1918, when they thought that the whole German nation should be united in one state. But this was also the peculiarity of Germans who live in many parts of Europe, including as well Switzerland and some other parts. So from that point of view, there's still different Austrians, Switzerland, Germany, and so on and so forth. So that's why probably, but we know that the actual federation, and even the federation before German Democratic Republic joined the Western Germany, it was not completely the same federal states, the same lands, federal lands, as they were during the previous period, even during the period of the Constitution of 1871. By the way, even in the Constitution 1871, it was very interesting that probably, I'm sure that you know, but anyway, just permit me to recall you that we call the German emperor as a Kaiser, but in the Constitution was the president of the German Empire. The president of the German Empire is the King of Prussia. It was also interesting. So they tried just to unify Germany as a federal state. So what about Italy? The situation is a little bit different, because since the beginning they tried just to unify it without preserving these peculiarities of different territories, especially in the situation that all German territories, they were considered as German, by the way. In Italy, not all of them, because the southern part belonged to the dynasty of Spanish Bourbons. It's also interesting because Bourbons not original Spanish dynasty, but they have as well as some kind of branch in the southern part, Neapolitan state, and so on and so forth. So from that point of view, they tried just to unify them from the very beginning, rather than try to make a union of Italian states. That was the difference as well from the historical point of view, if we may. But on the other hand, there's still differences, and there's still there is a so-called project of federalization of Italy. You know that regions in Italy, they are quite self-sufficient, and to a certain extent they are autonomous. They're considered to be autonomous. And there were several attempts to convert Italy in federal state. The last attempt, if I'm not mistaken, was around 10 years ago, when this project was seized in Senate. It passed through the lower chamber of the Italian parliament, but in Senate they just stopped the project. But it's still in some kind of a pending project, because even earlier they tried to do it, and there is a strong movement, especially in the northern Italy, for the federalization for different reasons. I don't mean just to go deeper into detail, but probably now. So from that point of view, history also just following us, as Marx once said that the dead person tried to catch by a leg in a live person. So from that point of view, it has some historical peculiarities are following us as well. And Germany, they prefer to maintain their federal state, but there were also different projects when there were only 3 constituent units or subjects of German Federation, and then 5, and finally they decided just to go to what we have now. But what we have now, it's not completely the same what they had on the verge of the unification in 1870 and even later, 1871. So because that's why we have a land which is called Rhineland-Westphalia, which is just unifies in reality 2 former states. We have Saarland, yes, as a separate land, but it's because of also peculiar history, and so on and so forth. So sometimes we can explain the territory by history, the territorial changes by history, but not always. We need also to understand the differences in self-identification as well. But by the way, there is no possibility, there is no attempt to create a federation in Germany based on ethnicity. Although not only Germans live, there are some people who might be considered as also long living. I don't mean to use this concept of indigenous people, but anyway, there are people who lived there since the beginning of Germany. This is Sorbans in Brandenburg and Saxony. They have even just some cultural autonomy, and as well Frisians in northern western part of Germany, on the boundary with the Netherlands, and some other also people's nations, I don't know, ethnicities, who live on the territory of Germany, as well as Italy is still preserved. For example, Bolzano. Bolzano is almost completely German-speaking region. Everybody who visited may notice that only the capital, Bolzano, which is Italian-speaking. Everywhere people speak German, the Austrian version. That is why sometimes they call it, it is called Southern Tyrol, as just connection to the Tyrol in Austria. And still there are some questions there. There are also Ladino in the Bolzano region as well, but they live in small municipalities. They do not they didn't comprise the whole territory, while German-speaking people are the majority. So still there are some questions. That's why I say that more questions are raised than answers have at the end, in the end of the day. But anyway, thank you very much for raising these issues, and thank you very much for giving me the floor, and for giving me the possibility to explain myself. I'll be very pleased just to hear some other people raising or answering or raising some other issues as well. Thank you.
Yes, thank you.
Do you have any other questions or comments? If not, if you don't mind, we will go further. Dear Professor Afternoon, many thanks for your commentaries. So I'd like to go further, and our next participant is Bernard Gangley, PhD in Political Sciences from the University of Verdun. The report is Indian Federalism and the Problem of Protection of Minority Languages. Well, Barna, please take the floor.
Yeah. Thank you for giving me this opportunity. I am very glad to here to present my topic. So my topic is on Indian federalism and the problem of minority languages. Okay. So first of all, in my demonstration, I wanted to figure out some points, main research questions, which I will be based this topic. So my question first of all, my question here is that how far does Indian federalism is qualified or disqualified in protecting the minority language rights? Okay, as India is a diverse country, it's one of the largest diverse. There is various largest populated country, and also it is a very diverse country as well as. So, and my second question is, as because there are very various communities which are lived in India. So the question here is that these communities, all these communities are if these communities are getting liberty, equality, and justice, is federalism can provide these communities a protection or accommodation or something? And my last question here is that India is, as we all know, India is called a federal linguistic state, a federal state. But how far it is, it can implement this protections, or how far India give these protections at the grassroots levels? Okay, so first of all, I will discuss what is federalism and the question of minority. So as we all know that federalism means shared rule and self-rule. Okay, shared rule and self-rule. So but the question here is that ethnic identity. India is a very diverse country, as I said earlier, that ethnic identity, especially the question of minority communities, has not occupied very important discussion in is very important for multicultural countries. But the classical federal concept, where the ethnic identity or their accommodation was not focused enough. But in the current debates after 1990s, after the globalization, the concept of multicultural, multilinguistic identities and their accommodation was focused. Okay. The main drawback or the problem with federalism here is that the federalism is only focusing on its territory and territorial problems and their recognition or something. But as it is a diverse country, there are various states, there are 28 states and 8 union territories. All the linguistic communities or tribal communities or caste communities, they are not isolated or located in specific area. So they are spread across the country. So they are spread across the country, and their rights, how much of their rights are accommodated and how much of their rights are protected through constitution or through federal principles in India. So then I will discuss about specifically about India. So how far India is successful in providing or managing linguistic identity. As we all know that after the Indian independence, India has to face a lot of traumatic experience because the division was based on the religion. So Indian government decided to focus on linguistic and tribal identity. So the federal concept is based on central government and state government. So distribution of power. So the main distribution of power was focused on those states are formed on the basis of mainly on linguistic and tribal identity. These identities was the basis of to form India, especially the linguistic identity. As we all know that the linguistic identity was highly focused on Indian case. The first, after the formation of State Reorganization Commission in 1956, the first state which was formed is Andhra Pradesh, and the last state which was in India, which was formed on the basis of language, was Telangana. So most of the states in India were formed on the basis of linguistic identity. But at the same time, there were many problems which we can highlight it that in India there are various communities, and they have their own mother tongue, and they have their own script, their language, their cultures. They are different from the rest of the community in a particular state or in a particular region. They located they are located, and but they are different from each other. Their culture scripts, they are very different from each other. And how does Indian federalism will accommodate this? So this is the question. So Indian Constitution, which gave in this linguistic community very good protection through various rights, especially in the fundamental rights. As we all know that fundamental rights are basic rights, which are provided by the Constitution of India, and which is for Indian government, Indian people who are citizens. So through this Article 29 and 23, 29 and 30, Indian Constitution tries to protect their linguistic rights. If any linguistic community wanted to establish their schools or anything, they can establish it. And there are various protections also, like in that 347 article 347 article, where in article 347 any minority language of a state can use their language as a state language. Okay. And article 350, 351 and 350d 50b, the main focus here is on preserving the languages and the scripts. There are various scripts and languages in India, so the main focus here is to preserve the languages and scripts. Okay. And in Indian Parliament and in the Indian Parliament, Indian Constitution tries to protect their interest and promote their mother tongue, so they can speak in their mother tongue and promote their mother tongue and their cultures, their ideas, their values, their ethos, etc. So in Indian Constitution, Article 120 protect their rights through that in the parliament they can speak in their own language and script. So as we see that India is one of the largest country, as we all know, and it has a huge diversity. It's not only in the linguistic terms, it has really various kind of religious groups, various caste, various creeds, various identity groups, various tribal identity. So there is various heterogeneity here. Okay, so this heterogeneity affects the country's political socio-economic structure, because the more this country got heterogeneous, so the accommodation will be very tough. The accommodation process will be getting very tough. Okay, so according to the People Linguistic Survey of India, India has the second largest number of languages. India has various languages in India, so many languages, 780. But according to 2011 census report, only 121 languages are considered as mother tongue. Okay, there are 780 languages. Only very few languages are declared as a mother tongue, and in our constitution, in the 8th schedule of our Indian constitution, we only protect 22 languages. Okay, so so this was the main problem here. So there are various languages, but very few or limited languages are protected through constitution. There are only two official languages, English and Hindi. There are various mother tongues which are neglected day by day. So the main problem here is that various communities which are excluded, and their rights are not articulated. They didn't get the protection from the constitution of the federal idea. Okay, so here I mentioned some states and their union and their principal languages. So in India, there are 28 languages, as I said, and every state is different from other. Okay, not only every state, even the districts, even the sub-districts, even the talukas or villages are different from rest of the state or rest of the area. Okay, so every state has their own language and own culture. So here I mentioned about it. And then I will focus. So who are linguistic minority in India? As I said, according to the Commission of Linguistic linguistic minorities are those which are at the state level or groups. These groups have different language they can speak in a particular state. They have different language, they have different culture, they have different scripts, they have different ideas. They are totally different from the rest of the state or the area. Okay, so in India, linguistic minority commissions tries to protect their rights, and they just established a linguistic commission. Okay, but there is a problem. There is a various problems, like this state recognition commission and the linguistic commission. There are various recommendations. There are various mechanisms to protect the linguistic minority, but in reality at the grassroots levels, they did not provide any kind of proper reports. They did not send proper recommendations. They did not fulfill the recommendations especially. So there is various problems. And in India, as I said, there are various languages. Only 15% of the mother tongue, only 15% of the languages are only 15% of the languages are give protections. Okay, those languages which are spoken by more than 15% are get protected. Other languages are not get protection from the constitution or the federal idea at all. Okay, so here the states-wise linguistic data. As I said, there are various states, there are various linguistic minorities which are deprived from the constitution. They have very few opportunity by the Indian government, and they are neglected in various spheres of life. So there are huge number of linguistic minorities in India. They did not get their protections from the constitutions. So what is the problem? What is the condition of linguistic minority in India? Indian constitution and Indian federalism tries to protect their interest through various constitutional rights, various commissions, various committees, various reorganization body, but in the reality, but at the grassroots levels, but in the village level, but at the talukas levels, the minorities and their mother tongues were neglected and deprived. There are various communities who qualified their school without knowing their mother tongue. They have no knowledge about their mother tongue, how they can speak, how they can write it. So there is a very big problem. They did not get any book for mother tongue, so huge number of children, they lag behind of education. They have to fail. They have to left the education system and do something else. So there was a very big problem. So recently, UNESCO has declared that there are various languages which are becoming endangered. Their existence is overall losing. Okay, so in India, 220 languages are losing and they become endangered. Okay, so there is a very big problem. And most of the cultures of minority communities, most of the scripts, most of the ideas, most of the language identities are lost when most of the because as after globalization, the problem is worse, because after globalization the English became the English became the a prime concern. And in India, especially Hindi domination is a very big problem in India, because most of the states and most of the programs, most of the awareness and most of the government work were done by Hindi and English. So most of the people in India which belong to the linguistic minority community, they did not know how to speak Hindi or English, so they did not access the facilities which are provided by the Indian government. So that's a very big problem in India. So I will conclude my topic with that. In India, there was a very big problem of representation, participation, and accommodation. So it is very common in diversified country, because India is huge diversified country where various peoples lived with their own language, scripts, religion. So there was a very big problem. But Indian government and Indian constitution tries to protect their interests through various commissions and committees. But we have to take care of the grassroots level, because the main focus, we should always focus on the grassroots level, because at the grassroots level the mechanism is very poor. They did not the poor people, mainly the minority linguistic groups, they did not access to their facilities. They didn't have any idea about which kind of facilities they will get, or they were not available. So they did not get any grant, or there is no mechanism for the protection or development of minority languages. So that's it's my topic. So thank you.
Dear partner, many thanks for your report. Dear participants, yes, please.
Well, good afternoon. Thank you, partner, for your wonderful presentation. My name is Irina, and I would like to ask you. You expressed your own views on the problem of national minorities, and it was quite interesting. But I would like to ask, in what way, in your opinion, the practice of the regulation of the institution of minorities will go next? Like, what do you think? What should be introduced in the federal documents, maybe in the constitution next, besides the different commissions, as you said? Because I think, as you said, the Indian society is multicultural, it's diverse. So it's really hard to maintain the balance between these, not only between the languages, but also, as I know, the differences between, for example, poor and rich states. This problem has been around, I think, since the country gained independence. So despite constant attempts to solve it, I think such types of problems are always actual. So what do you think? What are the next tendencies of the normative regulation of the institution of minorities? Thank you.
Thank you. Thank you for your. I just wanted to tell you that there should be various mechanisms across the world. There, not only in India, there are various scripts or languages or various minority groups. There are various countries in all over the world where various communities live together. But we have to focus on the grassroots level. If we take care of the grassroots level, then all the problems of the state level and at the central level will be solved automatically. If we educated these poor people and the ignorant people at the in their mother tongue, they will become very they will become knowledgeable person, and they have no, I don't say that in Indian constitution or in the constitution there are no protection available or something like that. There are huge protection for them, but the problem here is that Indian people, mostly minority linguistic peoples, they did not have the idea that they have this kind of facilities to them. Okay, so they did not know about the facilities which Indian government will offering them. So they didn't know the official language. Okay, so they didn't know Hindi, they did not know English or other languages. So they did not have any idea about these national languages. So they only know about their own language, their own script, their own area, nothing else. So we have to educate these communities and preserve these communities and their rights, their scripts, as it is very important to take care of these linguistic ideas and rights, because there are various communities in India which are very important to take care of this, because it is a diversified country and we have to accommodate these identities and protect these identities. If we don't accommodate them, then it's a huge problem for us. Then it will not be a federal country or democratic country. It will be a totalitarian country, because we will focus on English and Hindi. So we will what I say, we will just impose upon them. If we impose upon them, then the diversity, then the diversification was not fully acknowledged or fully utilized in India. So this is my point.
Thank you so much, Parla.
Thank you.
May I, with your permission?
Yes,
I have just two questions. I don't know if it is easy to answer or not. First of all, thank you much for your presentation, for your speech. It's very interesting and knowledgeable. Then I have a question. If there's any differences in the states' approach to the minority languages, because states may have their own programs of support or may not. Probably some states are better in this field or not, or everywhere if the situation is okay. And in your opinion, to what extent states may be involved, or it is better just to promote federal programs for the minority languages, or cooperation between states and federation, or it's better to encourage states to be more active in promoting their own programs, because as far as I know, the majority of minorities live within the states. Some of the minorities live in different states, but the majority of the minorities, they're attached to this or that state first of all. So from that point of view, what is the role of states in India in this field? I know that Indian states do not have constitutions, but they have their own legislation and they have their own powers. And to what extent they might be involved in the promotion of the minority languages? Thank you very much.
Thank you. So I think the state should promote their own languages and scripts. They should protect their own peoples, because there are various states, as I said. If one state protect any kind of community or various communities, then other state will inspire by them. And so the main problem here is that the central government, the control of central government, in sometimes state government can't do anything without central governments because of financial reason. Financially, the state governments are dependent on central government. So if a state government wanted to introduce any scheme for the protection of minority groups or languages, they have to depend on the money on central government. So I think the balance, the central government should help the state government in promoting the diversity, in promoting linguistic as well as other diversity, because the main focus of India is unity in diversity. Okay, so main focus of India is unity in diversity. So we have to maintain unity through diversity. We have to help each other in terms of our language, in terms of our script. We have to acknowledge others' personal opinions, others' views, others' languages, scripts, and festivals as well as. So if we maintain our diversity, we will maintain our unity. So we have to focus on unity in diversity.
Thank you. Thank you very much.
Thank you so much. Thank you so much.
I have a question too. Thank you for your report, first of all. And the question is, according to the Article 29, each minority, including language minorities, have the right to conserve their languages. But there are no obligation, if I'm not mistaken, there are no obligation of the state to protect languages of minorities, except those which are named in the schedule number 8. And there are 22 of languages, which is to me a lot to use on the federal level. And the question is, which rights in India minorities have to use their languages? For example, do they have a right to perform in the courts with their minority language, or make their local acts or bills on their minority language? Which means we need in India, like scientists offer, to solve this problem, because 22 languages are a lot, and like why this list seems to be difficult, I think. Thank you.
Thank you. There is no provisions here in India that the minority people will legislate minority people will make their own laws regarding their own languages. They didn't have any special rights like this. This 20 as India is one of the diversified country, so in India only 22 language is very limited. I don't say that I don't wanted to include that in 8th schedule. We have to include more 120 languages in it, but we have to acknowledge their rights. we have to acknowledge their education. I just wanted to introduce our mother tongue as a basic education. As in 2020, we made a new education policy in India, where we just focus on the mother tongue education. We wanted to focus that up to class 3, children should get their education in mother tongue. Okay. So because there are various in various states, there are various communities, so they have to opt for not for their mother tongue. They have to opt for national languages or the state languages in their area. So Indian government and the new education policy just focused on mother tongue. They have to if this communities does not have any basic idea about their mother tongue, it will be very difficult, and it will be difficult for our future that we can't protect our language. Okay, so then various languages are become endangered, and they are not available to they are not available to some groups. Okay, I just wanted to say here that not the tribe, not the linguistic minorities have enough right to make rules, regulations for them. They have they have no right regarding this. Okay.
And how many languages and on which criteria you want to conserve?
I just wanted to ensure that minimum 5% of the mother which is spoken by 5% should be considered, should be prioritized as mother tongue, and it should be acknowledged as mother tongue and give protection to them.
Thank you.
Thank you so much.
All right, dear colleagues, any other comments, maybe questions, something like this? No? Dear partner, well, many thanks for your report, for your comments. I wish this problem will be solved soon. By the way, we need to go further, and let me introduce to you our next speaker, Irina Strahova, student of the Faculty of Law, Lomonosov Moscow State University. The topic is the Institute of Federal Responsibility, the Russian Federation, and the Republic of India. So, welcome.
Could you please turn on my presentation? It's called Russia India. Well, good evening again, dear colleagues. Yeah.
На рабочем столе это.
Yeah, Russia India. Good evening, dear colleagues. My name is Irina, and I would like to talk with you about the institution of federal responsibility in Russia and India. First of all, it's necessary to clarify why such line of comparison arose, because like what's the point for you and me to sit here and to search for certain patterns in the system of in the systems of these two states? First of all, both Russia and India are complex societies with large territories and disproportionate development, and I think Pana's report showed that quite clearly and correctly. Secondly, both states are highly centralized federal systems. And thirdly, Russia and India are political regimes close to authoritarianism. Federal responsibility itself is quite an interesting construction, at least because it appears not only as a legal, but also as a political category. It's applied in the cases of the violation of the constitution and federal legislation by the federation itself, by the subjects of federation, by the government bodies, and by the officials. The next point of the institutional federal responsibility is the fact that it often occurs without fault. It's often called like a guilt-free responsibility. For example, when the highest official of the subject of the Federation, in the opinion of the Federation, fails to cope with his duties, though he may not breach any norms, he may be still being dismissed. And also the penalty function here is not so important, because the main goal of the institution of federal responsibility is not to punish the violators, but to restore the unity of the state by quickly eliminating non-compliance with constitution and other federal legislation. And then I would like to draw with you and to move to the most interesting part of my report, I think, because it's the comparison of the grounds of the foundations and measures of federal responsibility in the two states. So even in technical design, Russia and India are quite similar, because they do not have the clear list of grounds and measures of the federal responsibility. And to find them, I think it's necessary literally to jump throughout the text of the constitutions and of other acts and literally collect all the necessary information one by one provision. And so I would like to draw with you, and here you can see two diagrams. The first one and the second one. So let's stop on the first one. The black dots are the norms which were taken by me from the constitutions, and the white dots are those not listed in the constitutions, but they are contained either in federal laws, in federal legislation, or generally doctrinal. The higher dots are the grounds, the basis, the foundations, anyway, and the lower ones are the measures. And I would like to go from the left to the right and to show you every provision which I found in our constitutions, and not only constitutions. As for the Russia, the first basis, you can see that I found that was the contradiction of acts of subjects to federal acts. And this basis correlates with three measures. As you can see, one is named in the constitution, and it's called the recognition of the provisions of such an act as inconsistent with the constitution and its loss of the legal force. And you can see two lines which go to the measures which are not listed in the constitution. The first one is suspension by the president of the act of the highest official of the subject, and the second one is the dissolution of the legislative body of the subject. The second basis is the second foundation is the existence of the circumstances that are a direct threat to the life and safety of citizens or the constitutional order of the Russian Federation, and the elimination of which is impossible without the use of emergency measures. And the measure is declaring a state of emergency. The third basis is the aggression against Russian Federation or an immediate threat of aggression, and the need to ensure the country's defense and state security. And the measure is logically introduction of a martial law. The fourth base, as you can see, it's not mentioned in the constitution because it's like the white dot, and it's the publication by the highest official of the subject of an act that contradicts constitution, and the evasion of highest official from issuing an act providing for the abolition of a suspended act or from making changes to the act. And the measure is also not named in the constitution. It goes like right to the top white dot at the bottom. The measure is responsibility of the highest official of the subject, and it can go like in different ways. First of all, it's the issuance of the warning by the president. The second one is announcing a reprimand by the president. The third one is temporary removal by the president of the highest official of the subject, and the fourth one is the whole dismissal by the president. The fifth base is also not mentioned in the constitution. It's the impossibility of exercising powers delegated to public authorities of the subject, and the measure is withdrawal of delegated powers from such public authorities of the subject. The sixth base is also not mentioned in the constitution. It's the situation of natural disaster or catastrophe or another emergency situation in which government bodies of the subject are absent and cannot be formed, or the situation of an overdue debt, so like the complicated financial situation when it occurs. And the measure is temporarily exercised by federal government bodies of certain powers of bodies of the subject. And the last one, the seventh, and I think the most interesting basis, is also not named in the constitution. I called it improper performance of duties, or somehow the need for better performance. And it correlates with, as you can see, three measures. The first measure is named in the constitution, as you can see, it's the black dot. It's the appointment of the representatives of the president. And two unnamed measures. The first one, dissolution of the legislative body of the subject by the president, and the second one, the responsibility of the highest official of the subject, about which I have already said before. And then we should go to the next diagram. This is the diagram of correlation of grounds and measures of federal responsibility and India. And as you can see, all the dots are black. I didn't found anything which was not like taken from the constitution. All these grounds and measures are mentioned in the text of the constitution. And you can see that the amount is absolutely different from the Russian constitution. The first basis is incompatibility of laws with fundamental rights or their derogation, and the measure is invalidation of any law that diminishes fundamental rights. The second measure, the second base is inequality of citizens' opportunities in matters of employment, and the measure is promulgation by parliament of any laws that prescribe to remove such an inequality. The third base is so-called certain contingencies relating to the functions of the governor of the state, and the measure is the establishment by the president such provisions as he considers appropriate for the government of the state. The fourth base is also citation from the constitution, failure of the constitutional machinery in Delhi. So this is the situation when the administration in Delhi cannot be carried out with the accordance of the provisions of the constitution. And here the measure is the suspension by the president of any provision of an article connected with the administration of Delhi, and taking by him any necessary or expedient actions for the administration of Delhi. The fifth base is the conflict between laws of the state legislatures and the laws of the Parliament of India, and the measure is voiding the law of the state to the extent of its inconsistency with an act of the Parliament. And the sixth base is inadequate protection of communications equipment of national or military importance, as well as railways within the state. And the measure is giving instructions to state on the proper protection. The seventh base is also citation from the Constitution, certain cases. What are those? The measure is giving the state government or officers powers from the union. The eighth base is public interests related to trade, commerce, and communication, and the measure is imposition of restrictions by parliament on such trade, commerce, and communication in the public interests. The ninth base is shortage of goods in any part of India, and the measure is issuing a law by parliament giving any preferences to one state or another, or making any discrimination between one state and another for solving such situation of shortage. The 10th base is the existence of a serious, the first variant, of a serious emergency as the result of which the security of India or any part of it is being threatened. And the second variant is the situation of like when the financial stability or credit of India or any part of it is being threatened. And the measure is proclamation of a state of emergency. The 11th base is also citation, failure of the constitutional machinery, but now not only in Delhi, but in other states. So the situation when the state governments cannot function in accordance with the constitution. And the measure is direct presidential ruling. And the last one, you can see that there is only one ground and 6 measures. So I united the grounds in only one because it's been cited like from the constitution. The grounds is called special responsibility. It's like a special ground for the responsibility of governors of states listed in the special articles of the constitution. And such articles are the example of the guilt-free responsibility, federal responsibility I talked about at the beginning. And these measures include a whole bunch of articles. I would not read them to you, but I can say that the measures are, for example, maintaining law and order, or ensuring the proper functioning of the Legislative Assembly Committee, and so on. And before moving to the conclusions of such an analysis of these diagrams, I would like to show you 2 more diagrams. And as you can see, they are absolutely, the first one and the second one, as you can see, they are absolutely the same. I simply marked in red those grounds and measures that seem to me the most floating and the most broad ones. And as for the Russian Federation, I think that the most like dangerous ground is not mentioned in the constitution. It's, if you remember, improper performance of duties or the need for better performance, because this is one of the features of the federal responsibility as a responsibility without guilt, because it doesn't have a specific normative source. The constitution doesn't say anything about the reason for which a particular official is being dismissed. And it's the widest provision. It correlates with the measure which is also floating, because it's the responsibility of the highest official of the subject. And here the president can dismiss the official also because of the citation from the constitution, loss of the confidence of the president. And what is the situation of the loss of the confidence? Nobody knows. As for the India, you can see that the amount of red points, red dots is absolutely different. And I would not repeat here in reading you the provisions of the Indian constitution, because I already did this before. But I would say that Indian floating provisions, as I marked them in red, include such terms as certain contingencies, such provisions as the president considers appropriate, failure of the constitutional machinery, taken by the president any necessary or expedient action from his point of view, and so on. So you can see that there are many provisions which are quite similar in both federations in the type of terminology, because they are absolutely floating, I think. And as for the conclusion, first of all, I think we should return to the Indian variant of constitutional norms of federal responsibility, and say that, first of all, we see that the Indian norms are much more specific and varied, because they do not end with the basic contradiction of some laws, for example, the laws of the subject to the federal laws. But the Indian norms range quite widely from, as I said before, inequality in employment, protection of communications, trade, commerce, shortages of goods. So you can see, you can clearly see the social orientation of the measures. And it's like an attempt to eliminate the inequality of the states, as Parna said before. And in the constitution of Russian Federation, the norms are not distinguished so specifically. Plus, the diagram shows that the Indian version is much more accurate and consistent, even despite the huge size of the constitution, because, like you can see, they are absolutely direct and quite beautiful. And our variant, I think it's chaos. However, that's important not to forget that the difference between the constitutions is almost in 50 years. And despite the least similarities, as I said, because both countries are multicultural and they have like complex structure, despite the least similarities of the two countries, the circumstances of the development were still different, historical circumstances. Plus, the Indian constitution is basically larger, and it's also more flexible due to the simple procedure for introducing amendments. And after all, at first glance on the first diagram, so like first diagram in the Russian variant and in the Indian one, the Indian version looks so much smoother and slimmer than the Russian one, as I said. But however, that's why I actually did the second pair of diagrams to determine the broadest provisions. And so here you can see you would like to say that it's the most beautiful and accurate variant, but then you turn out the next, the most dangerous points marked in red, and see that everything is not so simple, because there are much more norms with like metaphorical formulations precisely to the Indian version, which seemed to be less metaphorical at the first sight, because here you can see beautiful, and then you can see that there are quite a lot of norms with red flags. And again, this is not about good or bad. I just wanted to show that nothing is so certain. And of course, you could reasonably say that all the rules, not only those marked in red by me, can turn out to be broad and dangerous in practice, that behind each of them can be politics, and there is politics, and if necessary, they can be turned out into any direction. If you would like to, you will do this. And you will be absolutely right. But however, in this case, will it even make sense to talk about this institution of federal responsibility, about the constitution itself, and about constitutional law in general, in whole, if we see, besides everything, politics, and cannot go away from this term? I have already said that federal responsibility is inseparably linked with politics, and this is obvious. But it seems to me that we should not complain about the fact that we cannot break away from politics, but we should try to systematize and to build a more logical structure of this institution of federal responsibility as the example, and other ones in constitutional law, so as not to jump around like this throughout the entire constitutions, the federal acts, acts of subjects and states and so on, and court decisions and also like, doctrinal positions in search of the needed norms. And the key problem with all of this is precisely that all of these norms are floating, and the red ones are especially floating. And if I haven't marked other norms in red, it doesn't mean that they are not floating, and you can like put anything into them and arguing that it's the discretion of the president or something similar. And do you understand that what happens to them in practice? They are, you can do anything with this. And actually, this is all. But I would like, usually the audience asks the speaker, but I would like to go first. And I have for about 3 or 4 questions to you. And I would like to ask you, all of you, dear colleagues from the reader, I would like to ask you, my first question is, in my article, in my report, I in fact pushed together 2 approaches to the institution of federal responsibility. The first one, I didn't say about it, but the first one, some authors were, as I read, some authors were of the opinion that federal responsibility is an absolutely simple and understandable institution, because the authors believe that there is no need to search like this to dig into the text of the laws and constitutions, because the authors believe that the ground of the federal responsibility is the only one, a violation of the norms of the constitution and federal legislation. And in this case, all my diagrams, this one, all my diagrams could be thrown away and reduced to the simple contradiction of one act to another ones. And the second position, which I tried to make, I tried to show that this institution doesn't have a clearly regulated list of norms, of bases and measures for the so-called federal intervention. And I think it's useless to reduce such a huge and colorful bunch of different provisions to the only one ground and only one measure. Like we have a violation of norms of the constitution of federal legislation, and I don't know, the measure of cancellation of the norms which contradict constitution and federal legislation. What do you think about these 2 models? Maybe it's really better for us to reduce everything just to contradiction of local acts to the constitution as the basis and the abolition of contradictory acts as the measure. Maybe we really don't need to do like this. What do you think?
We shall answer one by one.
I don't know, if you want.
Please do not hesitate.
Parna, are you here?
Are you with us?
Yeah, I am.
So if you don't mind, please share with us your opinion.
Hello? Hello?
Hello.
Yeah, I can hear now. Yeah.
Okay, maybe I can express my view. In my opinion, barring in the text like this is a more correct approach, simply because, as you can see, everything is not so clear, as I said, because, for example, you can see that there is a foundation which has several measures, or there are several foundations and only one measure. And okay, we can agree that there is only one basis, as I said, the violations of the norms of the constitution, and only one sanction, and that's it. But after all these chaotic passings of laws into pieces and trying to find something not so clear than it's like it looks like, these things are the attempt to determine the real state of affairs, and I think it's simply better than stopping on the first obvious position and I don't know, taking simply what we see. And my second discussional point was, if you remember at the beginning, I said that federal responsibility is applied in cases of violation of the constitution and federal legislation by the federation itself, by the subjects of federations, and by governing bodies and officials. What do you think about the federal responsibility of the federation itself? Because what do you think? Is it really possible? How can we theoretically explain it? Because we are used to the fact that federal responsibility concerns only the responsibility of the subjects and their bodies. But can there be a federation here? Because in my opinion, federal responsibility is carried out, it's the main feature of the construction of federal responsibility. It's carried out on different levels of federation, and this is the obvious sign. So accordingly, why can't we say that the measures can also be applied to the federation itself, not only for its subjects and individual officers and so on? This is, I think, one example in the legislation of Russian Federation. If you open our constitution, you will see that there is a norm about the contradiction of an act of the federation to the act of a subject adopted on the issues of its own jurisdiction. So usually we are used to the fact that the acts of the subject usually contradict the federal ones, but we have the norm which gives us the opportunity to use the act of the subject instead of the act instead of federal act. So I think this is the example of the responsibility of the federation itself. What do you think? Do you think federation can be the subject of such relations?
An opinion, and it depends on which position we stand for. On which position we stand for, which we described in the first report about, are the members of the federation the subjects of, or are they are those, do they have the sort of sovereignty to form, like, is it plural or is it singular to say people or peoples when we constitute the constitution? And if we, in my opinion, there are three cases in international law to success. It's occupied people, discriminated people, and colonized people. And I think that in the world, when we constructed the national state, when the state is aggregation of nations, the nation or the people is something that aggregates some small peoples, and consequently we have no opportunity to, we consider people like something aggregates small peoples, and consequently if we consider it only like that, we cannot give the opportunity to imply an liability from to those who don't have constituent power. Like if a member of federation doesn't have constituent power, so it doesn't have an ability to imply a responsibility on the federation. That's my opinion, and I repeat that it depends on which position we stand for the issue described in the first report.
Thank you. I also have quite an interesting question, which bothers me, because earlier I have shown you the mechanisms of federal responsibility, and one of the conclusions I made, I expressed it in the question, in the form of a question. Don't you think that through such mechanisms of federal responsibility, the balance of powers both in Russia and India can be changed so strongly that the constitutions and the federal relations will become unitary, not from the federation, because
that's not the question to me because it's more widely.
It's the question for all.
Yeah, it's more wide than this topic, and it has. There are a lot of scientific works on that, like Federation Russia as more symbol, like in Switzerland, and I think we won't deny it. So that's my opinion.
Thank you. That's all for now. Thank you.
So, dear colleagues from the Zoom, would you like to add something? No? Okay, so if you don't, it's true.
I think that in every institutional relations, it is like in private law synonym, and here responsibility in one level implies responsibility in another level, but it is not responsibility of all of this level. All these powers. It is responsibility of institutions and persons, but not all of federations. Because when we try to say that all federation can be the subject of responsibility, it was very dangerous to all of this interest. But if we said that federal institution, parliament or head of state or government, for example, here we can say yes, no problem. We can kick up that day, and it will be federal responsibility to balance interests of constituent members and federation. But we can't say that federal level is a one monolith subject of responsibility. That's my opinion.
Thank you.
So, thank you very much, Irina, for your reports. Tell the truth, your picture is coming fancy. But we need to go further, and let me introduce to you our next speaker is Daniela Isaev, student of Novosibirsk State University. The topic is adoption of new federal, accession of members of federation, general and practical issues. So you're welcome.
Yeah. Could you please turn on my presentation? Accession of members. Just a moment. Could you present yourself?
So, dear colleagues, let's listen to the next speaker, Daniela Isai, student of Novosibirsk State University. So, go well.
Hello all. It is my distinct honor to perform in my university with such relevant topic. As accession of new members of Federation, in my 7-minute speech, we will together consider issues. First, general issues like how do accession and other associated terms relate, what is the accession precisely, and what is the role of international law during this procedure. And particular issues like which states' constitutions provide such opportunity and what's the national legal order of accession in Russian Federation and other foreign states. And let us move to the first of the general issues. How do accession and other associated terms relate? First of all, it must be understood that accession is one of the forms of self-determination of people. And whether we classificate it on whether external or internal, legal or illegal, bilateral or unilateral, you could see that, like whether it's external and no, we cannot see it. Whether it is external or internal, related to enlargement of the territory or related to the contraction of the territory, legal or illegal form, bilateral or unilateral, we could conclude that accession is external, legal, bilateral form of self-determination of people related with enlargement of the territory. For example, it distinguishes from secession, which is associated with contraction of the territory, or distinguishes from occupation of the territory, which is associated with illegality and unilateral character. And now, when it's vitally clear what is accession precisely, we are moving forward to the issues of international law in this procedure. Well, accession procedure aggregates from 3 blocks of rules. First is mandatory rules of international law, jus cogens. Second, international legal treaty. And third, finally, domestic law. Mandatory rules of international law provides 2 blocks of norms. There are conditions and consequences. For example, the main condition of accession is free will of the acceding states. And among consequences, there are succession, for example, archives, property, and whatever, according to the Vienna Convention of 1978. What about international legal treaty? It regulates 3 blocks of 3 rules, for example, 3 blocks of rules, and there are status of the acceding state, there are public institutions and their organization, and succession. Like parties could agree on another, which is established by the Vienna Convention of 1978. And finally, the domestic law provides the powers of parties to participate in accession procedure, and sometime in some cases, for example, like in Russian Federation, there are national procedure of accession. By the way, the absence of such procedure in domestic law results in the non-occurrence of relevant international legal consequences, but in no way deprives state from this opportunity, but in no way deprives this opportunity, no way deprives the state from this opportunity from the view of international law. and dealing with this issue in domestic law ad hoc, like in specific case. And we are moving from general issues to particular ones. The author of the study concluded from the above that the international legal procedure precedes domestic law and its transformations. International law doesn't provide for a unified procedure, but sets out the conditions and consequences of accession. And finally, the failure to comply with the international legal conditions for accession results in the non-occurrence of relevant international legal consequences, but doesn't preclude the occurrence of actual effects and consequences under domestic law. The next issue is the constitutions of which federal states explicitly provide for the possibility of accession of members of federation. And the author of the study has examined, here you can see on the diagram, that of 28 federations of the world, there are 16 of them, including Russia, provided an explicit possibility to access new subject or new member of the federation. And as we are short of time, we're moving forward to the particular order of Russian Federation's accession procedure. Let us take attention to the slides. Here is a procedure described in the Federal Constitutional Law of 2001. It is ensured at let me see. Here is the procedure, and it is aimed at ensuring a high degree of legitimacy through the will of the president and parliament, as well as ensuring a high degree of legality through the assessment of agreement of compliance to the constitution by constitutional court. But if we would see the procedure on how do these rules are applied on the practice, we could see some problems. And here are the first one we will consider together. Article 65 of Russian constitutions provides the composition of federation, and it implies that until the new subject is named in this article, it cannot be considered as a member of federation. Article 9 of Federal Constitutional Law provides that amendments to this article are made on the basis of federal constitutional law. And despite that fact, treaty between Russian Federation and Republic of Crimea, for example, at 2014, and with Republic of Lugansk and Donetsk in 2022, consists such provision. Republic shall be considered as admitted to the Russian Federation from the date of signing of this treaty, instead of the procedure consisted in federal constitutional law and constitution. So we see that, and I should mention that Federal Constitutional Court admitted such procedure as constitutional. The departure date, according to the Constitution, is amendment to the Constitution to the Article 65, but according to the treaty, the departure date of membership is the date of signing by the President of Russian Federation. But we're moving forward to the foreign states procedure, and we would consider the example of the United States. Constitution of the United States doesn't provide the possibility of accession. But if we would see the practice of the state, we can conclude that there are two varieties of such procedure. First, you could see international legal treaty requires 2/3 in Senate, and the second one, joint resolution, simple majority of both houses of Congress. And first example, when the consequence of enacting an international legal treaty was Louisiana Purchase in 1803. Louisiana became state at the moment the act was enacted. And the second one, when Texas and Hawaii was adopted to the federation, there were problems. For example, in Louisiana Purchase, the balance of Senate powers was strong in favor of accession, 27 against 4. And Texas case was more hard to the President James Polk. It was obvious that the balance not as strong as it was in Louisiana Purchase. And the President, James Polk, initiated adoption of joint resolution, which requires only a simple majority instead of 2/3 of Senate. And with a really weak balance, 27 against 25 in Senate, it was adopted, Texas, like a state. But joint resolution is not the only form that used to adopt states. It also it is also find out that incorporated territory, to which the constitutional guarantees are applied in really limited manner. For example, inhabitants of Hawaii don't have their representatives in Congress, or they cannot participate in president elections. There are, we can conclude, two procedures in the United States, and they are, if we are precise in our terms, the United States are not only the United States, but the United States and incorporated territories. So we're moving to the conclusions. Accession should be regarded as an external, legitimate, bilateral form of self-determination related with enlargement of the territory of a state. And the international legal procedure precedes domestic legal transformations, and it is a condition for them. Of the world's 28 federations, 16, including Russia, provide the explicit possibility to access new member of federations. The enshrined accession procedure envisaged in Russia complies with international legal standards, and it is, and this procedure is characterized by a high degree of legitimacy and legality. However, the practice of application of legislative norms can be significantly improved, as we have mentioned. And the accession of new territories in the United States can be realized through the form of international legal treaty or through a joint resolution of the houses of Congress. And as we have mentioned too, distinguish and difference between them is the number of the powers, the balance of the powers in the houses of Congress. So thank you for the attention. I'm ready to answer your questions.
Well, Danilo, many thanks for the presentation of the procedure. It was clear and nice one. Dear colleagues, do you have any questions to the speaker? Well, sure.
Okay. As you noticed, the fact of having international treaty, for example, of the United States, according to your presentation, leads to creating a state, like example of Louisiana, but there is a case of Alaska, which was purposed in 1867 and became state only in 1959. So could we say that the international treaty in the United States practice could lead to creating incorporated territories, not states, or maybe other different pitfalls in my understanding of the thing? Thank you.
Hawaii had the status of a state. They had granted this status in 1959 too, same as the Alaska. So we can say that this procedure is not bound the states, the United States of America, but it provides the possibility to adopt new member to the membership and not provide you the relevant guarantees provided to the states. For example, in 2016 and 2017, the Supreme Court of the United States considered a case where some of the incorporated territories complain that their social payments are less than in the states. If you know, Medicare and Medicaid social programs in the United States. So inhabitants of incorporated territories couldn't use these programs completely like inhabitants of the states could. So answering your questions, the adoption or accession of new territory through the joint resolution doesn't bound the states, and it could be further, its status could be changed to the state status.
Thank you.
Yes.
Any other questions? Dear colleagues, technical assistants, could you please tell me what are our other participants in the Zoom? Are there anyone
Кристиана Давила просит слово, у него встреча скоро, он может сейчас, если Хомяковой нет. Если Хомяковой.
Sure. Dear, so colleagues, I'd like to I would like to give the word to our expert, Christian Altavilla. PhD in Law and Social Sciences, Professor of Constitutional Law, Subnational Constitutional Law and Public Law, National University of Cordova and Siglo, 21 research, and he's a recruiter. He would like to give us some commentaries. Dear Christian, please welcome, take the floor.
Hi, hello. Hi, Vadim. Hello, everyone. Thank you very much for letting me to be part of this important event. I like to thank especially to Vadim for his kind invitation. I'm from Argentina, so it's very important to me to be part of this international forum with discussion of different issues of federalism. I am actually working as a researcher at CONICET, which is the National Research Council in Argentina, and my first topic of research is federalism. Right now, I am working on fiscal federalism, which is a very complex topic from a constitutional and institutional perspective, not an economic perspective. I'm not an economist. I try to mix different methodological approach from political perspective and from constitutional perspective. So first of all, I like to thanks again for your kind invitation. And well, my presentation is about the role of constitutional court in intergovernmental conflict resolution. I would like to share with you the Argentine case. This is a paper I was working during the last year, and I finished this year. I'm trying to publish in an international journal. The question behind this topic is whether it's a legal question, whether federalism is a constitutional principle, and if it's so, if courts can apply them in different legal cases. So classical literature on federalism has identified different prerequisites, precondition, or requisites to the formation and survival of a federal polity, right? In other words, a list of factors making federalism work. In a summarized list, we can identify the following condition of success, like the ideological factor, historical condition, sociocultural factors, and so on. However, little attention has been paid to institutional factor, and that's why I like to point it out today. This presentation will focus on an institutional aspect, which is neglected by classic literature for the survival and workability of a federation, and is the role of the Supreme Court in resolving intergovernmental conflict. What has triggered this question? I began to study this particular topic since the last 15 years. The Supreme Court in Argentina began a species of a new judicial federalism with a lot of very interesting ruling cases in which the Argentine Supreme Court began to apply explicit and implicit or non-writing federal constitutional principles, and very interesting cases in which were involved the constituent parts of our federation. Our federation is made of the federal government, 23 provinces, we call them provinces, like in Canada, and one autonomous city, which is the city of Buenos Aires, which is at the same time the capital of our nation. In these different, each case was very different in the resolution and the conflict itself. There were conflicts regarding the competence during the pandemic. There were conflicts regarding fiscal issues and so on. But what is interesting on all this ruling is that we can identify some main features of our Supreme Court that established constitutional principles and some guidelines. So how this conflict should be resolved at the end. So that's triggered the question, what is the role of an apps court in any federation? So in order to answer this question, I try to make a comparative analysis looking different institutional settings in other federations. Well, first of all, there is a theoretical framework. As you may know, since the beginning of the federalism as a polity system itself, there were these two main literature: the political safeguard versus judicial safeguard. Those who argue that problem raised in the intergovernmental sphere must be resolved by the actors involved themselves in the political field. In this sense, there are some specific institutions provided by the constitutional setting, such as a second chamber, for instance, or different intergovernmental spaces like the conferences or the commissions, intergovernmental commissions, etc., etc. And those, on the other hand, who maintain that they are matters that can be adjudicated and therefore put the task of resolving this conflict before the courts, applying the law and the principle that govern that relationship. So this second literature sustained that federalism is a constitutional principle and it should be, as such, be applied by the court and especially by the Supreme Court. Well, taking a look at different federal system, we first met with the German case in which the Constitutional Court is very famous for its jurisprudence and the so-called constitutional principle of federal loyalty, very spread around the world, even expressly adopted in many constitutional texts. For instance, the Belgian Constitution or the South African Constitution. The Federal Constitutional Court is very well known for a long and inveterate jurisprudence on constitutional principle of the German federalism, but at the same time, it recognized that its own jurisdictional limits in applying this constitutional principle. So it's like a species of intermediate position. In the case of Belgium, it's very interested because the principle was originally conceived in a political and not judicial sense, so it was expressly outside the competence of the court. These issues were to be resolved through political channels to be designed by ordinary legislation. However, from 2010, courts began to make application of this principle to suspend and even repeal federal rules that undermine the principle of federal loyalty. And finally, with a legal reform, the sixth state reform made in 2012, the principle of federal loyalty became a formally justiciable principle, being part of the block of constitutionality and as such enforceable by the Constitutional Court. In Austria, the Constitutional Court is competent to resolve dispute concerning consultation mechanism provided by the Constitution, and since these mechanisms came into force in 1994 until 2014, there had been no recourse to the court. So all dispute has been settled politically. Only in 2004 did the court decide a case, an isolated case, where it declared that the federation has violated the consultation mechanism on the cost of railway crossing for Austrian municipalities. But it's like an isolated case. Certain constitutional texts lean toward the political settlement of intergovernmental dispute rather than the judicial ones, although obviously without ruling it out. These systems seek to encourage resolution through dialogue between the parties involved and only resort to judicial resolution as the ultima ratio of the system. For instance, and I have much time to explain these cases, but I just will mention them. The very interesting case of Italy, South Africa Constitution, Switzerland, Ethiopia. Sorry, was repeated. It's a mistake. Among them, Ethiopia and South Africa, I found the very interesting case. For instance, the Supreme Court of the South African Federation has systematically repealed actions made by provinces in South Africa because the Supreme Court argued that the political mechanism were not completed to resolve the case. So they have to first follow the political channels stipulated in the ordinary legislation, and if they can resolve their conflicts through these channels, ultimately they can go to the Supreme Court. So there are a lot of cases where the Supreme Court rejected actions that were put forward for the provinces with this reason. There are between both models. We can identify alternative models, yeah, between these two extreme positions. Some scholars have put forward a more intermediate position, like Bednar, Gardmount, Vicky Jackson, for instance. And almost all constitutional courts and tribunals have made an extensive application of the constitutional principle governing the relations between level of government. So it can be concluded that the doctrine of justiciability of constitutional principles currently predominates in all modern federations. So this mechanism of resolution has not displaced the political mechanism, which is at the foundation of the federal institutional structure, and without which any type of federation would lose its very essence. It is in the light of the criticism of this judicial activism that a third model has recently emerged in contrast to the two classic models, the procedural approach and the substantive approach, with two basic characteristics. The importance of the intergovernmental dialogue and the fact that they are based on constitutional principles, such as, for instance, subsidiarity principle, solidarity principle, the federal loyalty, constitutional principle, among many others. So the role in the Argentine Supreme Court of Justice in the resolution of interjurisdictional dispute or intergovernmental dispute was a very interesting case during the last 15 years. We need to first mention that the Argentine federalism copied the model of the US federalism. It was very, very similar. We have this a very similar judicial system with the Supreme Court, with almost the same competence and attribute of that of the American country, American federalism, the US Supreme Court. We have a judicial review system of constitutionally control. It's not an abstract control. It's a concrete control, different from the European or the Austrian model of constitutional control. Well, in these cases, there are like more or less like 20 rules by the Supreme Court with different intergovernmental conflict of different nature and different topics. We can identify some characteristic in these sentences, in this new jurisprudence. First of all, the court recognizes and analyzes the fundamental problem in which the case under study is inserted. For instance, when a municipality in the province of Buenos Aires was sued because of a local tax, for the constitutionality of the local tax, the Supreme Court not only analyzed the legality of this specific tax, but also made an analysis of the whole fiscal federalism system and the main problems that affect our system, which are a huge problem, very long-rooted problem. We were not able to resolve yet. And it's very interesting because the court made a whole narrative explaining what are our most important problems from the fiscal policy, and it's not restrained themselves to analyze the legality of the tax only. Second, it shows deference to other powers and parties involved. So it recognized that who has to resolve the conflicts are the parties itself, that they have their own resources to negotiate and to resolve the conflicts. Third, encourage dialogue. In many cases, during the process, the court has called the parties to an audience, a public audience, and in resolving the case, has established, for instance, to create, for instance, a new commission integrated by both or all the parties involved, with a representative of each one of the parties involved, and they have to discuss in these new commissions this specific problem. For instance, these kind of solutions was adopted in environmental conflicts between provinces. The problem of the water here in Argentina is a very important topic regarding intergovernmental conflicts between provinces. The court encouraged dialogue through the creation is mandatory. The court obliged the parties involved to create a commission composed by a representative of each province, and they have to make an agreement through this commission. Fourth, exhort the party to comply with the constitution and its objective. It says, in many cases, you provinces or federal government, you are not compliant with the constitution. For instance, there are a lot of constitutional disposition or a lot of constitutional mandate that after 30 years, because we are going to turn on the 30th anniversary of our last constitutional reform of 1994. Our original constitution is from 1853, is our current constitution, but it was reformed in 1994, and especially in federal matters, it's established a lot of mandates, for instance, to sanction a co-participation regime, a system of a system to share fiscal resources that was not sanctioned until now. So, for instance, the Constitution exhorts the parties to negotiate and to sanction this law, among many other constitutional mandate that was not complied until now. And finally, that it is very important, sets guidelines for future actions. The court itself says that in his ruling, the court wants to put some guide forward so that it can be used as a guideline for the actor himself for futures conflicts, that they can resolve these conflicts, taking this precedent, and they can resolve the conflict itself. For instance, for instance, in one case, during the COVID-19 pandemic, the federal government ordered the lockdown of all schools in the city of Buenos Aires, only in the city of Buenos Aires. So the city of Buenos Aires claimed, went to the court and claimed his autonomy and said, I have my own constitutional autonomy to decide whether or not I will close my schools. And the court gives the city the reason and says, of course, you are autonomous. The national government cannot decide these things, especially cannot decide in an unilateral matter. Maybe if they were negotiated, it's another thing, but it was unilateral and it was, of course, unconstitutional. But what is the most interesting fact in this case? That the court issued its ruling after the federal decree was enforced. It was just not enforced because the mandate of the lockdown of school was until one date, and the court decided the case after that date. So the case became abstract, and in our system, tribunal cannot decide in the case that became abstract. So the court anyway issue its rules because it says this is an important case and can be repeated in the future. So to avoid another legal case and to provide some guidelines to the parties to resolve the case themselves, I will issue this rule. So I think this is very, very important. And some to conclude, some preliminary conclusion, there is no doubt that apex courts are playing a key role in modern federation. As Erin Delaney has warned, the role of apex courts in constitutional development is widely seen as a central aspect of modern constitutionalism. And in a federal system, courts participate in structuring and mediating the very societal conflict that contributed to the initial desire for power sharing. However, this role varies widely across federation. In Argentina, the court has acquired a leading role through its recent jurisprudence, clearly opting for a system of judicial safeguard without disregarding, of course, the political mechanism, because the court itself encouraged the use of political mechanism. The Argentine court's own rulings show the importance of this political mechanism, even saying that are preferable to the court intervention. What ultimately the court is saying is that those conflicts must be resolved by the parties themselves. Okay, thank you very much for your attention, and I'm open for questions and comments.
Well, dear Professor Christian Alavia, many thanks for your reports. Dear colleagues, if you have some questions, please ask our speaker. Would you like to ask something?
I want to say your presentation was brilliant. Thank you very much.
Thank you. Thank you very much. I will. I haven't taken a look at the Russian federal court. So if you can provide me with some cases, I will be more than happy and grateful. So we can compare our cases.
We will need.
Thank you.
Thank you.
Any questions? Okay. Dear Professor Christina Lavia, many thanks one more time. And we are going to go further. And I would like to introduce to you Evangela Gribova. Evangela is here.
If he in the Zoom, he isn't here. Yes.
Oh, okay. Okay. So our next speaker is Sergei Bavkatov, student of the Faculty of International Relations, Political Science and Foreign Regional Studies, Institute of History and Archives, Russian State University of Humanities. The topic is Constitutional Foundations of Federalism in the Late USSR and Modern Ethiopia, a comparative analysis. So please welcome.
Good afternoon, colleagues. As I said before, the topic of my report is Constitutional Foundations of Federalism in the Late USSR and Modern Ethiopia, a comparative analysis. Please, could you give me this magic device?
Does work?
Doesn't work?
If it's, I think because it's not.
Could I use the
F5?
Okay.
F5.
Okay, so let's start with short introduction. In contemporary world, there are 28 states that declare themselves federation or have some features of a federal state, and it's about 40% of the world population live in these states. And according to opinion of many scientists, in the 21st century, the ethnic or national question has intensified considerably. So these two previous facts encourage scholars around the world to study federations, including the national territorial federations. This form could be a useful tool in accepting the demands of ethnic autonomy. So, in the modern world, there is an example of national territorial federation with a sharp ethnic question, Ethiopia, and moreover, it retains the right of secession for different parts of this country. And it brings to mind the comparison of Ethiopia to the one historical state with the same unusual for many federation right, Soviet Union. I decided to choose this late Soviet Union for comparison because it had a constant number of federation members. As you said, as you know, maybe from 1920s to 1915s, there was active national construction. So by the period of accepting the Brezhnev constitution, this number became the constant in number of 15. Okay, then let's talk about the definition of federalism. This article uses a definition of federalism given by PhD and professor of Kazan Federal University, Mithat Habibovich Farukshin. And according to his definition, federalism is a complex phenomenon that includes three groups of elements: ideological, legal, and cultural elements. So let's review one by one these elements. Ideological component set the purpose of federation existence and serve as the value basis for unification. The legal one allows us to understand the interests of parties and different political actors for taking part in a federation treaty. And cultural element won't be reviewed in this article, but we will also review such an important legal element as the rules of federal games, which means that we are talking about the status of center and regions, including the region representation and right for succession from both of these constitution states. Okay, firstly, let's start with ideas and ideology in constitutional order of these countries. One of the key grounds for comparison of the states is their ideological uniformity, because the ruling parties of both countries share Marxism-Leninism ideas, and moreover, Tigray People's Liberation Front, which was in the coalition named as the Ethiopian People's Revolutionary Democratic Front was also close to be Stalinist. And two political parties with the same views, like Tigray People's Liberation Front and the Communist Party of the Soviet Union, create two different ideologically filled texts of the fundamental law. For example, we could conventionally label as follows: Soviet way and Ethiopian way. Soviet way is the model of dependence of the federation on ideology. For example, according to the preamble and the 70th article of the Soviet Constitution, the main purpose of Soviet Federation existence is to build communism. And Ethiopian way is the model of proclaiming widespread among world community values for any possible situation. It's a democratic order, the rule of law, and social and economical development in preamble. And history has shown how the loss of faith in communist ideals was one of the reasons for the collapse of Soviet Union. Therefore, it's worth to recognition that the Ethiopian way is a path to the stable and adaptive federalism, which can be filled with the different content, for example, conservative, liberal, or socialist. Then we're going to talk about the circumstances of constitution adoption. There are different circumstances which affected the specificity of the constitutional adoptions. To simplify the report a bit, we can highlight three case elements. Firstly, it's weakness or strength of the authorities at the moment of adoption. As stated before, interethnic relations are critical in Ethiopia. Therefore, the change of power in 1991 also led to overthrowing the large Amhara ethnic group by the comparatively small Tigray people. The new government needed to consolidate its position and made concessions to different political actors, especially for the different ethnics of Ethiopia. And in comparison, in the Soviet Union, the positions of the Communist Party was very solid. Ethnic factor is the second point. There were the historical competition between Ethiopian peoples. It affected the specifics of the link between such concepts as region and ethnic group in their constitutions. On the other hand, the process of formation of ethnic republics was accelerated in the Soviet Union, and it explains the understanding of such concept like Union Republic in more territorial way than in Ethiopia, because, for example, the republics of the Middle Asia was created during the period of 20th century, and it was, shall we say, adult republics. And the third point is international situation. The Ethiopia found itself in a difficult international environment when the socialist camp had disappeared, and it forced Ethiopian politicals to be a bit West-orientated in writing its constitution. And the Soviet Union had a good relations with the Western countries, so there was a sense of influence of these countries on the Soviet version of constitution. For example, in this text we could find such concepts like Soviet people and personality, and the union of peasantry, workings, and intelligence. The other main point is, as I said before, rules of federal game. So let's start with the centralization or decentralization of both federations. And as I said before, two ideologically close regimes under quite different circumstances created two different constitutional designs, while preserving the national character of the federation at the right of succession. Firstly, let's start with the centralization, as I said before. After this comparison, we could say that Ethiopia is an example of decentralized federation, and the USSR is an example of centralized federation according to the system of power distribution between region and center. For example, in Ethiopia, the federal center has little authority about making a central public policy, and he would set only the general plans of this policy. And its exclusive scope of power includes very common for many federations questions like citizenship issues, national security, foreign policy, and presence of the federal center in international relations. And interesting fact that the protection of the federal constitution and management of lands and natural resources are placed in the joint responsibility of regions and the center. In the Soviet Union constitution, actually, federal center had the key leverage over sectoral public policy in the form of control over country's economy through state planning. This point decreased the proclaimed independence of socio-economic development of the regions. A number of points in federal scope of power more than in Ethiopia, and includes different other parts like making the jurisdictional laws of republics the same as federal. Secondly, let's review the right to succession and representation of regions. The USSR is more territorial side state. As I said before, the understanding of the Union republics is not similar with Ethiopia, because in Ethiopia, ethnic factor plays more role in the politics. So in the Ethiopian constitution, we could see that the right of succession given not only for the Union republics, but to nationalities and peoples of Ethiopia. And this constitution, there thought that these groups could be presented by different regions of Ethiopia. And in Soviet Union, these republics have this right to succession, but not the peoples of these republics. And according to the system of representancy of the regions in the federal level, we could notice that in Soviet constitution, give me a second. Would you give me water, please? The representatives of regions in the federal level is organized by the having 32 representatives in the lower chamber of Supreme Soviet. It's a Soviet of nationalities. And in Ethiopia, there is a very interesting system when each nation, nationality, and people must have at least one representative in the lower chamber, and it could have additional representatives, one by each million of population of these people, and different quotas for ethnic minorities is a very common practice for the Supreme Chamber of the Ethiopian Parliament. Okay, in conclusion, I could say that USSR and Ethiopia have many similarities due to a close ideological orientation, as well as differences due to the rather unlike circumstances of adoption of the constitution. And the centralized nature of Soviet Federation and its ideological content can be explained with the logic of the previous development of the Soviet state. And in particular, for example, the absence in the first years of existence of Soviet Republic, different peoples in the face of union republics. And the Ethiopian constitution of 1995 was adopted in the context of centuries-old interethnic confrontation and the weakness of the new government, which led to its decentralized nature. Thank you for your attention. I'm open to different commentaries and questions.
Well, dear Sergey, many thanks for your report. Dear colleagues, are you ready to ask any questions? Let me proceed. We have one more participant.
It's Vadim Aheyev, our colleague from London.
Okay, that's one.
Great Britain. Hello.
So, hi there. Well, dear colleagues, do you have any questions? Not, let me ask a question to our speaker. So you have focused on the fact that both of these directions had a right to succession. Do you think it is indispensable right in the federation? Is it a firm principle for a federation?
Thank you for your question. I don't think that it's maybe such a harmful or something else principle in the constitution because of one simple reason. You could use this right in the situation when the all federal treaty is, shall we say, useless, because any Union Soviet republics use it only in the situation when the Soviet Union was collapsing. So, like in Ethiopia or the Soviet Union, this right will be sleeping until the situation when different political actors decided that it's better to be an independent state than a region will be taking place. So thank you.
Thank you. Dear colleagues, we should go on. And our next speaker is Alexander College. Lecturer at the Faculty of Law, University of Belgrade. Hello. Hello. Please take the floor. Your topic is federalism in football, the case of Bosnia and Herzegovina.
Yeah. Good evening, dear colleagues. Good evening, everybody. My name is Alexander Nikolic, as you said, and I'm a lecturer at Belgrade University, Faculty of Law in Serbia, where I teach constitutional law at undergraduate studies. It is a great honor to be virtually again in Moscow and to participate at this great conference. I'm very thankful to the Vadim, who kindly invited me to this great conference, to be part again of this great conference. And because of this conference, this great project, I had opportunity to meet one brilliant young lawyer, young man. His name is Yegor Kramarenko, and he knows Serbian and Bosnian constitutional law better than some Serbian and Bosnian scholars. But now I will talk about my topic, which is quite interesting for me, and it's a federalism in football in the case of Bosnia and Herzegovina. So, despite the enormous literature on federalism in constitutional design and the growing attention to the sports law, especially particularly in the context of the football or soccer, there has been remarkably little attention paid to the interaction between these two. So my idea, my presentation seeks to provide a summary how federalism, using the example of football in Bosnia and Herzegovina, can be significant for building peace and trust between three constituent people of Bosnia and Herzegovina, Serbs, Croats, and Bosniaks. So therefore, my presentation has two primary aims. The first aim is to explore federalism in Bosnia-Herzegovinian football using the example of the football championships in Bosnia. And the second is to illustrate how federalism today operates in the organizational structure in the Joint Football Association, FA, of Bosnia and Herzegovina. So some authors before me talk about Bosnia and Herzegovina, and we all know that understanding Bosnia is not an easy job. So that country has a highly complex structure, often overlapping and sharing similar competencies, while the whole state remains contested for numerous sites, composed of two entities or federal units, the Federation of Bosnia and Herzegovina and Republika Srpska. Dayton Constitution does not per se name the country federal state. So that is a good point for the scholars all around the world to create their own qualification of the Bosnian and Herzegovinian state structure. So we can see the names like confederation, federation, the union, confederal, federal state, etc., etc. That is very important. Also, when we talk about football, the football as the most important secondary thing in the world, and the sport that promotes values of tolerance and respect. Namely, after the conclusion of the civil war in Bosnia in 1995 and the signing the Dayton Peace Agreement, the new established country does not function in all aspects as a federal state. How can we talk about that? How can we see that? We can see that, we can illustrate that in the example of the football, where there is no unified Bosnian-Herzegovinian Football League and Football Association. Instead of that, there are 3 separate leagues for Serbs, Croats, and Bosniaks, and 3 separate football association. So the first part of my presentation is to analyze 3 phases of the organization of football championship in Bosnia and Herzegovina. So when we talk about first phase lasts until 1998, and we can call them disintegration of Bosnian Herzegovinian football. Why? Because in that period of time, we had 3 separate football associations and 3 separate football championships. For Bosniaks, there were Football Association of Bosnia and Herzegovina. For Serbs, there was a Football Association of Republika Srpska, and for Croats, there was a Football Association of Herceg Bosnia. And all of these football associations had their own football championships. For example, the first champions for Bosniaks was Čelik from Zenica Football Club. For Republika Srpska, it was Football Club Boksit. And for Croatian side, that was Football Club Široki Brijeg. When we talk about next phase of the evolution of the organization of football championship of Bosnia and Herzegovina, we can speak about the period that lasts from 1998 until 2001. And we can call them commencement of reintegration. Why? Because we have the strong pressure of the European Football Association, UEFA, to create a unified football association for all 3 constituent people in Bosnia and Herzegovina. But we also had the situation like this. The Football Association of Republika Srpska withdrew from that negotiations in the last phase of negotiation, and UEFA and Bosniaks and Croats create a playoff championship for the BiH, Bosnian Herzegovinian football champion, between winners of the Croats and Bosniak football championship. So we have that first step of uniting Croats and Bosniaks. And now we have that last third phase, which we can call the federalization of Bosnian Herzegovinian football. And it began in 2001, when we had first the agreement of establishing a joint football association for Federation of Bosnia and Herzegovina for Croats and Bosnia. And that is very important to highlight, because you know that according to Dayton Peace Agreement and Dayton Constitution, we had the Federation of Bosnia and Herzegovina from 1995. But after that, after 2001, and creating a joint football association for Federation of Bosnia and Herzegovina, UEFA create a strong pressure for the Republika Srpska, and the Football Association of Republika Srpska joined the first unified football championship and first unified football association of Bosnia and Herzegovina in 2002. And the first champion, just to take that notice, was the football club from Republika Srpska, Leotar from Trebinje, one beautiful town in the south of Republika Srpska. Also, when we talk about football in Bosnia and Herzegovina and the connection between football and federalism, we can talk about the organization of that joint football association of Bosnia and Herzegovina, because it is a good example of federal nature of Bosnia and Herzegovina. According to the current statute of the Football Association of Bosnia and Herzegovina from 2020, the Football Association of Bosnia and Herzegovina is defined as an association in which the Football Association of the Federation of Bosnia and Football Association of Republika Srpska are equally united. So constitutionally speaking, this norm indicates that the Football Association of Bosnia and Herzegovina was formed through the method of aggregation, or the joint together method, of the 2 entities football association. Article 9 of the statute further elaborates on this by specifying that the Football Association of Federation of Bosnia and Herzegovina consists of the 10 cantonal football associations. What is also important to highlight, when we talk about the organization of football association, we also have the executive committee, and it is the most significant body within the Football Association of Bosnia and Herzegovina. It consists of 15 members, and for example, 10 must be from the Football Association of Federation of Bosnia and Herzegovina, while 5 must come from the Football Association of Republika Srpska. So, interestingly, it is worth mentioning that this body also requires an extraordinarily high quorum for decision making. 12 present members. For decision to make, a 2/3 majority is necessary, with at least 1 vote coming from the Football Association of Republika Srpska and 2 votes from the Football Federation of Bosnia and Herzegovina, to be more precise, from the Croats and Bosniak member. So it is important to bear in mind that the national voting mechanism is a relict of the Dayton Agreement and the Constitution of Bosnia and Herzegovina. It was kept in mind by the delegates of the General Assembly of the Football Association of Bosnia and Herzegovina when formulating the current statute of the Football Association. Interestingly, UEFA has highlighted in its opinion that the statute of the Bosnian and Herzegovinian Football Association is very good and is based on greater participation of the 2-entity association. So, what can we conclude? I had 5 conclusions. First of all, is that in Bosnia and Herzegovina, after the conclusion of the civil war and the signing of the Dayton Peace Agreement, football operated as if it were a confederal state, as there were 3 separate football associations which functioned independently. The Football Association of Republika Srpska for Serbs, the Football Association of Herceg Bosnia for Croats, and the Football Association of Bosnia and Herzegovina for Bosniaks. Over time, thanks to the effort of the European Football Association, UEFA, a process of federalization of Bosnian and Herzegovinian football was initiated by merging the Football Association of Bosnia and Herzegovina, Bosnia Football Association, and the Football Association of Herceg Bosnia, Croats Football Association, into a single association and football championship. In football terms, Bosnia and Herzegovina became a federation in 2002, when the Joint Football Association of Bosnia and Herzegovina was established, composed of the Football Association of Federation of Bosnia and Herzegovina and the Football Association of Republika Srpska, along with the creation of the common Premier League of Bosnia and Herzegovina. The federal structure of football in Bosnia was confirmed also in terms of organization. The current statute of the Unified Football Association of BiH, following the model of the Dayton Constitution of Bosnia and Herzegovina, includes representatives from both entity association and all 3 constituent peoples within its bodies. Therefore, despite all the shortcomings of the current football structure in Bosnia, as discussed in this paper on this presentation as well, it seems that the present model is the only sustainable one that unites and connects the 3 constituent peoples, Serbs, Croats, and Bosniaks, in Bosnia and Herzegovina. Thank you very much. Spasiba большое.
Well, thank you very much for your report. Dear colleagues, do you have any questions, any comments? So please.
Alex, I just wanted to say I have no questions. I'm quite far from football, but that was absolutely fascinating. Thank you so much.
Thank you very much on this beautiful comment. I'm now finishing my PhD thesis about the systems of government in the modern federal states, and Bosnia is one part of that dissertation, as well as Russian Federation.
Alex, it's precisely because of the choice of such original topics that our conference continue to be so great. And my question is, in your opinion, are there prospects of comparative issues, comparative studies of Bosnian football federalism and Belgian football federalism?
Yeah.
It will be very interesting.
I read a few months ago, I read one article about political system of Belgium, and the name of that article was what Belgium can teach Bosnia. I think Belgium cannot teach Bosnia anything because Belgium also had their own problems in federal structure. And about your topic, we sent a few emails about that. And I think that we can connect Belgium Football Association as well as the Bosnia Football Association. So I think that in this way, Bosnia can teach Belgium some lessons. And we can see that I watched yesterday a football derby in Belgium. I don't know how I did that, but I did that. It was the football club from Brussels, the football club which supporters are French-speaking people from the Belgium, and Club Brugge, the football club which supporters are Netherlands-speaking people. So that derby highlight the violence, the one type of model that is not fascinating and not good. And I think that some idea of playoff maybe can be a reasonable solution for Belgium, a playoff between the Flemish and the Wallonian people, and the creation of maybe two different football associations. But who am I to talk about that? When we talk about Football Association of Bosnia, the president of that association, as well as the General Assembly, give the permission to Republika Srpska to play football matches, international football matches. So we are waiting that first football match after, I think, 30 years from the war, a first match between Serbia and the Republika Srpska. And I'm very happy to be at that football match, if that football match will ever be able to be played. So that's it. No strict answer, but one comment and one topic to think and to write about it. Thank you.
Thank you very much.
Thank you, my friend.
Thank you. Any other comments? Any other questions? Okay. Dear colleagues, many thanks for participation in today's session. I wish we proceed sharing our knowledge and didn't cultivate. But at the same time, if you have any questions, any comments, if you would like to share your opinion about an issue, you are free to share your ideas with us now. Would you like to share some ideas?
I'm proud of all of us because it happened. Thank you very much for all participants. It was great.
Yeah, absolutely. We highly appreciate your attendance at our conference. Well, today's session has demonstrated what cases deserve special attention and what cases are of non-age. We'd rather get rid of idealistic ideas being unbiased, and this is certain to be the main goal for our next meeting at this time in this place. I know for sure that there is plethora issues to learn in the comparative federalism to study, and it is our conference where you can freely share your opinions and ideas with us. I'd like to focus your attention on this nice book, and I'd like to remind you that after this conference, every participant is to be given this nice book with proceedings. So don't forget about this. So thank you for your attendance.
Alexa, I send you your.
Yes, absolutely. Nobody will be forgotten this time. It's a real page student, you know. So I hope to meet you soon. Many thanks.
Thank you.
Thank you very much.
Bye.